USCIS has new policy alert. They have made some changes to the policy manual, which is basically their guidebook to their officers on how to process your cases. So let's talk about what these new changes are and how it's actually beneficial to you for them to make these changes. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. So the policy changes are in Chapter 6, Section 8 of the policy manual. This is the section that deals with family-based immigration visa petitions. And these changes are on how USCIS handles correcting approval notice errors, requesting consular processing or adjustment of status, and how they route approved petitions. What is family-based immigrant visa petitions? These start with an I-130. That is the part where USCIS basically says, yes, this person meets all the requirements for this family-based immigration petition, and we're going to approve it. And the changes come on how to correct your approval notice. So once USCIS processes your case and they decide that you do qualify for this and your beneficiary qualifies for this and they approve your case, they send you an approval notice. And when you get the approval notice, look at everything that's on there because you want to make sure that it's actually correct. If something is off, if something is not correct, we want to get it fixed immediately. USCIS is now giving additional ways that these things can be fixed. So if it is a typographical error, so for example, they mismatched the name or didn't spell the name correctly, when you send it in, you put the name on there correctly, but they made a mistake on the notice, well, then you can send a typographical error request, basically telling them what exactly is wrong on the approval notice and asking them to send you a new one where they have corrected that error. Another thing that can be wrong on the approval notice is the priority date or the classification. For example, if you are the child of a U.S. citizen and when they filed the I-130, they indicated that you are the child of a U.S. citizen. They proved that you are the child of a U.S. citizen. But on the approval notice, it says that you are the child of a permanent resident. That is a classification error that needs to be changed. Because when it gets to the embassy, it's going to cause some confusions. And if it says that you are the child of a permanent resident when you are really the child of a U.S. citizen, you're going to be waiting longer for that visa. So you want to make sure that the approval notice has all the correct information, especially your priority date and your classification. With the new policy, you can request changes for classification issues and priority date issues on the approval notice. However, if you miss that is a problem and it's sent over to the embassy for processing, well, if the officer notices that is a problem, they can send the application back to USCIS for them to fix that error. So again, it's really important that you look at your approval notice and make sure everything is correct before it's sent off to National Visa Center and all of those things. You want to make sure that you are doing your due diligence on that. But if it is sent over to the National Visa Center and is sent over to the embassy, the officer reviewing it, if they catch that error, can choose to send the file back to USCIS for them to make the changes, because the officer at the embassy cannot make those changes for you. Only USCIS can make those changes. This is going to cause a delay in your case. So you want to make sure that you are looking at that and requesting those changes as soon as possible. If the file is with USCIS and you'll be filing adjustment of status with USCIS, the officer that gets your adjustment of status case can make those changes. So they can go in and reopen the I-130 to make the changes that are needed to update the classification or to update the priority date. Those are the only two things the officers can actually do. It is important to note here that the only two situations where the consular officer has the option to send the file back to USCIS for fixing an error is if there's a classification issue, the visa class, or the priority date is wrong. They have the option to send the file back to USCIS. That's it. If your name is wrong, you will need to take that up with USCIS. The officer is not sending the file back for that. However, if the file is with USCIS and you're doing adjustment of status, that officer can actually make those changes because they have fuller access to your file and they are the agency that approved the I-130 in the first place. The next change that they made is about the consular processing versus adjustment of status. So typically when you file your I-130, there is a section that asks you if the beneficiary is going to be applying for a green card in the US or if they're going to be applying outside of the US at an embassy or consulate. When you are filling out those forms, you have to pick one. Either they're filing in the US or they are outside of the US and will be consular processing, meaning getting their visa at the embassy versus applying for a green card in the US. Before this policy change, if you did not indicate where your file should be sent, what USCIS will do is hold on to it. If you select both US processing and consular processing, or if you do not select one at all, USCIS will just hold on to the file. They will not send it to the National Visa Center. They will not route it to the embassy. They will hold on to the file as if you're going to file an adjustment of status in the US. And when they send you your approval notice, it will say it on there that they are holding on to the file because you did not indicate if you wanted it to be sent to the embassy or not. And in those situations, you must file an I-824 in order for them to then route it back to the embassy. This is important because there's a fee for the I-824 and there's a processing time for the I-824. It can take time for it to be approved. In my office, that is one thing that we make sure is done correctly because it can literally delay your case for an additional 3 months to a year. It's really important that you do the I-130 correctly. I said this on every single video where I talk about the I-130. Make sure you're selecting where the person is actually going to apply for their permanent residency. Is it going to be at the embassy or is it going to be in the US? USCIS is trying to be nice and give the officers options of how they can determine whether to keep the file or to send it to the National Visa Center. Typically, if you leave that question blank, USCIS keeps it. Doesn't matter what you do, USCIS keeps it until you file that I-824. Now they have situations where the officer can actually decide to send it to the National Visa Center, even though you did not indicate where you want it to go, or you selected both US and the embassy. They can make that determination and send it to the National Visa Center, which means you get to skip the I-824. There's 4 situations where the officer is going to keep your file with USCIS. And the first one is if you file the I-130, you indicate that the beneficiary is in the US, and you also indicate that the beneficiary will be applying for adjustment of status in the US. They will keep that. The second one is if you indicate that the beneficiary's physical address is in the US, and you selected that there will be consular processing and adjustment of status in the US, well, USCIS is also going to keep the I-130. By the way, if you're getting value out of this video, do not forget to hit that like button. If you indicate that the beneficiary's physical address is in the US and then you do not select consular processing or adjustment of status, USCIS will keep that file. If you have no indications on your I-130, but the beneficiary also applied for adjustment of status in the U.S. already, they're going to keep the file. There are situations where the beneficiary's physical address may be in the U.S., but they must consular process. So if someone entered without inspection and they need a 601A waiver, which means they need to consular process, right? They need to go to an embassy for their interview to then come back with their visa to get their permanent residency. In those situations, their physical address will still be in the US, but they need to consular process. If you leave it blank, or if you select both consular processing and adjustment of status, USCIS is still going to keep that file. So again, your I-130 being correct is so important so that things are sent to the right places. Now let's talk about when they will send it to the National Visa Center. There's 3 situations that if you fall into these 3, they will send your file to the National Visa Center. And the first one is if you indicate on your I-130 that the beneficiary is going to be applying for a visa at the embassy. Secondly, if you indicate that the beneficiary lives outside of the US and then you don't select consular processing or adjustment of status on your I-130, USCIS is going to send that file to the National Visa Center. And lastly, if you indicate that the beneficiary's physical address, where they live, is outside of the US, and then you go and select consular processing and adjustment of status, USCIS is going to send that file to the embassy. Because again, by you indicating that the beneficiary lives outside of the US, they can kind of infer from that the beneficiary will be applying for the visa at the embassy. So that's why they will do that. Now, I will say this too. If you indicate on your I-130 that the beneficiary lives outside of the US and will be consular processing, or that you didn't even indicate which one they'll be doing, and the file is sent to the National Visa Center, just know if the beneficiary, let's say, gets a B2 visa, comes to the US and can adjust their status in the US, they can still do that even though the file was sent to the National Visa Center. Okay, sending the file to the National Visa Center is okay. It will not require you to file an I-824 to send it back to USCIS. The only thing you have to do is just apply for the adjustment of status in the US. If you are watching this video and you are thinking, I have an I-130 pending, and I did not say whether the person will be applying at an embassy or at USCIS, what do I do? Well, there's an option now, okay? The policy manual now gives you an option to send a letter or to let USCIS know the beneficiary will be applying for consular processing and which embassy they will be applying for that consular processing at. You can send a letter to USCIS at the address where your file is actually being held. The I-130 is being processed. So on your receipt notice on the bottom left-hand side, it will tell you the service center that has your file, and you will need to send them a notice saying, hey, by the way, I want this case to be consular processed at this specific embassy, and also include the beneficiary's address to show that they actually have residency in that country. If USCIS has already approved the application, then you need to go ahead and file the I-824. Sending a letter to the service center is only good if they have not approved your case. But once they approve it, the only way to fix it is to do the I-824 to get that file from USCIS to the embassy. Remember, the I-824 is only if the person needs the consular process, but the file is still with USCIS. Okay, if you make the mistake of having the file sent to the National Visa Center, but the person was supposed to adjust their status, all you have to do is apply for the adjustment of status. Those are the changes that USCIS has made to their policy manual, and these are beneficial to some applicants because it will make your life so much easier to correct errors, to make sure that your case is being routed to the right place, and gives USCIS officers more room to make determinations of where the file should go or where it was supposed to go in the first place. If you are going through your own family-based immigration process and you want to make sure that everything is done the way USCIS wants it, then go ahead and schedule a strategy session with me. Let's talk about how I can help you with that process and how we can work together. You can do that by going to my website, lilylegal.com, and clicking on Contact Us and select the date and time that works best for you for us to have a chat. You can also call my office at 508-443-1788 to schedule that strategy session.